Welcome back to Not Legal Advice, and as always, if you're on any medium other than YouTube, go to YouTube for the full video. Sometimes you can only post snippets of this on other social media platforms. So this is an update on the non-compete rule that the FTC put out some time ago, saying that non-competes are no longer enforceable. So just quick recap, and as a prior video, the FTC put out a rule, Federal Trade Commission put out a rule that said non-competes are no longer enforceable and requiring employers to provide notice to current and former employees, independent contractors, etc., telling them so. The deadline for that was going to be September 4th, but if you remember, I discussed with the U.S. Chamber of Commerce and some other parties filed a lawsuit against this in the state of Texas. Well, we finally have a ruling, and it's actually early. We didn't anticipate it to the end of the month. We got it a few days early, so yay. Anyway, good news. The judge in that case granted the plaintiff's request, and the FTC rule is banned nationwide. So, what does that mean, right? This means that non-competes still enforceable. The ban against them is invalid, at least for now, nationwide. And if you're an employer, you don't have to send notice out to employers or former employees stating that their non-compete was no longer enforceable. And number two, if you are under a non-compete, it is still enforceable. So be aware of that. If you are into the reasoning why, essentially the judge found that the FTC exceeded their rulemaking authority that they've been granted by Congress. They did not have the ability to ban non-competes, and that the final rule as presented by the FTC was, to quote the judge, arbitrary and capricious. So, long story short, the ban on non-competes was struck down. Non-competes are still valid and enforceable, of course, subject to the state laws that govern them. Now initially there was a big question about whether the judge's ruling would only apply to the parties in that Texas case. Originally, Judge Brown seemed a little uncomfortable expanding it past the plaintiffs or the parties that had filed the lawsuit, but ultimately the judge determined that setting aside an administrative agency action like this does have a nationwide effect, and therefore it applies to everyone. So the ban against the FTC rule applies nationwide. So it cannot be enforced at this time. Something to be aware of is we do expect the FTC to appeal this ruling, right? Because every case just keeps on going and going and going forever and ever. We do expect that they will appeal it and attempt to have the judge's decision set aside by the U.S. Court of Appeals for the Fifth Circuit. So be on the lookout, more to come. But for right now, that September 4th deadline no longer applies. Employers, you don't have to send out the notices about the non-competes. And number two, if you're under a non-compete or you're an employer utilizing a non-compete, it's still valid, still in force. Talk to your attorneys if you have more questions. All right, good luck out there.